So before the short adjournment, we've just finished looking at the Indian Tribunal's decision. I'd now like to go to a case of the Portuguese Supreme Court, please, which is in the Authorities Bundle, tab 31, and it starts at PDF page 590. And this is yet another case in another jurisdiction where the court is clear that Article 4.1 requires there to be, and the words that we'll see in due course, a real and effective personal attachment to the Portuguese territory. And so the position in this case, which you'll see from the summary at page 590, if I can just set out the bare facts. The taxpayer was a Portuguese national. He lived for more than 20 years in Germany. In 2001, which was the tax year at issue, he lived in Germany the whole year. He maintained a permanent home in Portugal, where he stayed for 30 days on holiday, and his wife and children lived in Portugal. So that's the premise. Under Article 16.2 of the Portuguese Personal Income Tax Act, that was a deeming provision. All the persons of a family unit are deemed to be resident in Portugal, as long as one of the persons in charge of the unit, and that meant one of the spouses, is a resident in Portugal. So pausing there, the situation was, as a matter of Portuguese law, he was deemed to be resident in Portugal by virtue of his wife's residence in Portugal. And in real life, so to speak, he wouldn't have been resident in Portugal because of the amount of time his physical presence in Germany. The Portuguese tax authorities took the view that the taxpayer had to be considered treaty resident of Portugal. And the taxpayer argued no. He also argued that even if his interpretation of the treaty was wrong, he didn't fulfil the tiebreaker tests. Now, this case is one of the last cases in a run of Portuguese Supreme Court cases, which we'll see from the passage I'm about to show you, where each time the Supreme Court restates the requirement for this personal attachment. And we have, in this case, the quote from the original case, if you like. So it simply gets repeated time and again. So just going through the document, 591 to 592 is the decision under appeal. So that obviously will set out the converse proposition. 593, you will see the facts summarised in paragraphs 2 to 4 of the judgment. If I ask you please just to go forward to 595, so paragraph number 17, Roman 5 and Roman 5.1 underneath that, you'll see that this refers to the reasoning of the court's previous judgment, and then you'll see that is quoted by reference to the facts of the previous case, which just so happened to concern Germany and Portugal in the same way, 595 through to 597. And the point that I particularly want to alight on, and I'd be grateful if in due course you wouldn't mind just please reading 595 to 597, that is I'm just making sure there's nothing that I want to take you to before. Yes, so actually 596, if I could ask you just to look at the paragraph starting the conventions, so this is the treaty, the conventions therefore take precedence over national rules which may by fiction establish the residence of a person by dependence in the country of a residence of one of the other members of the household. So that's a similar sort of reasoning to the reasoning we've already seen in Fowler. The paragraph then, next paragraph, on the other hand, it sets limits on the nature of the connection adopted by the domestic law. The paragraph after that is talking about the facts in the previous case, which you'll see are sufficiently similar to the case that the Portuguese court is concerned with. And then at the bottom of page 596, however, given that the resident status has to be analysed individually, the wife's residence in Portugal is irrelevant for the purposes of determining the conventional tax residence of A. In addition, the criteria, and then this, the criteria that may be used for the purposes of the Portugal-Germany DTC to determine the status of respondent A as a conventional resident must also be similar to those listed in Article 4.1 of the Portugal-Germany DTC, brackets, domicile, residence, place of management, i.e. they must be criteria, then this, that express a real link with the territory of the state, and a mere residence through dependence criterion, such as that set out in Article 16.2, cannot be used for conventional purposes. They need it for the purposes of the convention. This is because it does not itself express a real and effective connection of most economic activities with Portuguese territory, and so on. And then just for your note, PDF 598, the court goes back to apply that reasoning to the facts, and the outcome is, as you'd imagine, the same as it is in the previous cases. So 2 points of note. First of all, here is a further foreign court emphasising the importance of real attachment in relation to criterion of a similar nature. And you'll note that it's now the well-established position in Portugal, since the court here is merely following and applying its previous judgments. And moreover, this judgment is consistent with Fowler, so our own Supreme Court jurisprudence, in terms of the role of deeming provisions and the effect that a deeming provision may have to play. And this is another black versus white type case in terms of the deeming.
As to the status of this court, it says Supreme Administrative.
Yeah, so...
do we understand that it's the top relevant court?
So I'm very happy to be corrected, but as I understand, it is the top court for tax matters. It seems to me that if you have a public law type tax matter, there's another court. So for pure matters of tax, this is the top tax court, as I understand it. That was what my research told me, and if I've got that wrong, I'm happy for someone else to correct me, but that was as far as I got with my understanding. So then next, moving on to Crown Forest, if I may. If I could ask you, please, that is behind Authorities tab 23, PDF 452 in the Authorities bundle. Now, we've dealt with this case in some detail in our skeleton, just for your note, paragraphs 45 to 57. And the nub of our criticism is that the Upper Tribunal went wrong in placing too much weight on what we say were in effect obiter statements in this case and taking them out of context. And we say that the first tier was right in its approach to the case, and that's paragraphs 51 to 56 of the first tier's decision. If I can just start off, so the excitement about Crown Forest is here the Canadian Supreme Court has used words to the effect that worldwide taxation is the most similar criterion of residence, domicile, etc. And we say that when you look at and you understand Crown Office properly, actually the most it can be saying in the context of the debate before it is that worldwide taxation is necessary, but it's not ruling that worldwide taxation is also sufficient, nor could it be, because that wasn't the issue before it. And if I can just stand back for a moment, and this will make more sense when we go through the decision in more detail, but just with a divorce this from residence, just with an example, to make my point about the misapplication of Crown Forest here. So let's just assume a list of 5 things. Let's just say cow, elephant, dog, cat, mouse. If you ask the question, rosebush, is that of a similar nature? You can say, well, the most similar criterion of those 5 things is they're animals, and a rosebush isn't an animal, therefore it's not. If you then ask the question, trout, just because you've already decided that the most similar criterion is animal, and a trout is an animal, doesn't necessarily mean that that is the right answer. And trout may or may not fit in the list, depending on the surrounding context, so on and so forth. But I just wanted to give a really simplistic example, because simply identifying a very high level feature and saying, well, it's the most similar when you're looking at something different does not necessarily mean it's the only criterion and it's the right answer. And
is the fundamental point in Crown Forest that it was addressing a different issue?
Yes, exactly. And this is why I say at the end of the day, it's taking over to commentary just out of all proportion and trying to apply it as if it's some sort of binding law for a point that Crown Forest simply was not intended to address. So if I can just explain, just again at a very high level, the facts, and you'll see this in the opening passage. So the right hand is the French version, the left hand is the English version. 542 to 543, if I can just stand back and summarise the facts. So the question was whether the company Norsk was treaty resident in the US in circumstances where it was incorporated in the Bahamas and had a place of management in the US. Norsk was liable to tax in the US, but critically its liability to US tax did not result from its US place of management. Rather, it arose by virtue of its engagement in a trade or business effectively connected to the US. So the question was whether engagement in a business in the US was a criterion of a similar nature to domicile residence, etc. And if you look, and you can see the court's reasoning in the summary on page 453. But if you start off, for example, by looking at the way that the court approaches the question, PDF page 464, it talks about the plain language, paragraphs 23 through to 25 on the next page. The primary question that the court is asking here is why Norsk was found to be liable to tax, and reference is made to the criteria. And if I can just then move on to page 484. Can I ask you please just to read the 4 points in the conclusions and dispositions? So that would be paragraph 68 through to 69.
I've messed up my electronics, so can we just go back a stage? Paragraph 23, what page was that on? Make note of it.
I'm sorry, so the page we were just looking at was paragraph 23 to 25, PDFs 464.
464, thank you.
And the point that I was making there was the primary question was to ask why Norsk was liable to tax, and it makes reference to the criteria.
Yeah, I've got that. I'm just doing a basic markup point.
Yeah,
and then
sure.
Where did you want me to go next?
Then PDF 484.
484.
And I was pointing to the conclusions and disposition,
Yep.
which is the 4 paragraphs. So basically paragraphs 68 through to 69.
Thank you.
That's no problem.
Sorry, when you say 68 and 69, I can't see a 69.
Oh, sorry. So it's on page 485. The numbering is on the far right-hand side. It's very
yes, sorry.
slightly odd.
Thank you.
And so I just want to touch on a couple of points, specifically in the conclusions. Just in relation to little one, just to explain the point about a factual proposition which merely informs domestic tax liability, that was simply to say that in that case, liability to source taxation arose by virtue of engagement in a trade or business effectively connected to the US. That in turn posed a multifactorial test, and place of management was one of a number of factors in assessing whether that border test was met. But that indirect connection wasn't enough to say place of management gave rise to the liability to tax, because the taxation did not of itself arise directly by virtue of its US place of management. Engagement in a trade or business, etc., was held not to be a criterion of a similar nature, since it didn't result in a worldwide tax. Let's assume for the moment that the Vogel formulation is correct. The term should be understood to mean any locality-related attachment that attracts a residence-type taxation. We would say, well, all Crown Forest tells you is the taxpayer in Crown Forest failed on the second part of that two-part test. The status in question did not attract residence-type taxation. And you see from the summary at 3 that the Canadian court itself reached the same conclusion, that residence plus residence-type taxation equals treaty residence, because at little 3, the parties to the convention intended only that persons who were resident in one of the contracting states and liable to tax in one of the contracting states on their worldwide income be considered residents for the purposes of the treaty. So even if we look at paragraph 3 of the conclusion, the court is basically posing the two-stage test here. And I labour the point only because, for some reason, the fact that this case was deciding a different issue and so therefore wasn't directly relevant to our case, just was something that the Upper Tribunal didn't find attractive. I don't intend, and so far as we're concerned, nothing more can be gleaned from this case, precisely because our issue and our appeal wasn't the one the court was trying to decide. And indeed, there are also a couple of places where, for example, our thesis that you have to have a right based on the taxpayer's personal connection is referred to and adopted. So just to give one example, PDF page 479, paragraph 57. So 57 starts on page 478. This is a quote from, 57 starts off discussing the various sources. There's then a quote from an academic text which goes over the page to page 479 of the bundle. And if I can just read 4 lines down, a person or entity is considered resident if that country asserts an unlimited right to tax his or its income, that is, a right based upon the taxpayer's personal connection with the country, etc. So even some of the texts that were accepted by this court still go by the two-stage test.
That's a citation, is it?
It is, yes.
Yeah,
and you can see that from the bottom of page 478. And both the Upper Tribunal and the Malena Friend make a big deal as to what was said by this court about the second sentence in Article 4.1, but with respect, I just don't see that as having any bearing on our case, and in particular it doesn't prove that our interpretation is wrong. So that's all I intend to say about Crown Forest, and I'll deal with anything else relevant in reply. So the last foreign court authority that I'd like to refer to, please, is the Canadian Supreme Court, Alter Energy. Page starts behind tab 44 in the authorities, PDF page 939. And I suppose that the headline propositions that I just want to take from this case, because this was a case that my learned friend referred to in the Upper Tribunal found relevant and helpful to agreeing with my learned friend, is as follows. So it's Authorities Bundle, tab 44. Again, Alter Energy is not concerned with the issue we're concerned with here. In Alter Energy, it was agreed before the Supreme Court that the company in question was treaty resident in Luxembourg. And the question was whether the benefits of the treaty should nevertheless be disapplied under the Canadian GAR because of abuse. So that's a completely different question to the one that we're concerned with here. And the point that we're arguing about here was a matter of agreement in Alter Energy. The relevant connection in Alter Energy was incorporation in Luxembourg. Again, nothing to see here, because incorporation in Luxembourg is a relevant local connection. The further point is that there are actually some passages which do show that the Supreme Court considered that the two-step test is the right test on any view, and certainly nothing in Alter Energy contradicts our case before you. So if I could ask you please to go to PDF page 1006. Could I please ask you just to read, so you'll see in effect the conclusion of the majority, 92 through to 94. And so in a nutshell, I suppose one way to explain it is it's not a million miles away from our Halifax abuse test for VAT. But the circumstances on the ground here are Luxembourg resident company, because it is incorporated in Luxembourg, everyone agrees it is liable to Luxembourg tax and it has paid Luxembourg tax. The minister wants to say, well, hang on a minute, because it is entered into avoidance arrangements, we, the minister, or I, the minister, want to invoke the GAR. This company doesn't have, and the minister, in effect, invented sufficient substantive economic connection with Luxembourg. That is contrary to the spirit and the object and the purpose of the treaty. Therefore, it shouldn't be allowed to benefit from treaty benefits. To which the Supreme Court, in effect, said, well, bearing in mind that legal seat, so incorporation, is sufficient for treaty residence, we know that the spirit and the object and the purpose of the treaty is such as to include in treaty residence pure incorporation, a pure legal connection. And therefore, you can't say that the spirit and the purpose and the object somehow requires something more tangible and substantive. That isn't our case here at all, because we're arguing about step one. We're arguing about the very point that was agreed in Alter Energy. We are also not trying to say you have to have some sufficient substantive economic connection. We are simply saying you have to have some relevant local link, be that a formal a formal legal connection, or an on-the-ground territorial connection. It doesn't matter which, but you've got to have some connection. And nothing in Alter Energy can tell us that the Supreme Court disagreed with that proposition. If I can also point out a couple of paragraphs where, in fact, the Supreme Court itself acknowledges the need of the connecting on the ground, the local connecting factors. If you could please go to PDF 982. And you'll see at the bottom of, 53 and 54. Bottom of 53, bottom of 982, according to this provision, a resident under the treaty is a person who's liable to tax, ... by reason of one of the connecting factors listed. Over the page to 54, in the context of corporations, the liable to tax requirement is met under the treaty, where the domestic law of a contracting state exposes the corporation to full tax liability on its worldwide income, because it has residence in that state. Liability to full taxation is established by the nexus between that state and the corporation's resident status. And then the last paragraph, 67, which is on PDF page 991. In sum, the object, spirit and purpose of Articles 1 and 4.1 are to allow all persons who are resident under the laws of one or both of the contracting states to claim benefits under the treaty, so long as their resident status could expose them to full tax liability, regardless of whether or not there's actual taxation. And we've already seen paragraph 74 that we looked at earlier, justifying why in relation to some types of income, residence and the resident state is the state that should have taxing rights, whereas in particular in relation to passive income as opposed to the source state. And so I think, unless you had any other questions at this point on Alter, I'll wait to see what my learned friend has to say, because it's really his authority as opposed to ours. That then takes me to the last part of submissions, which is academic texts, and I would like to show you three of them briefly. And if I can just sort of explain up front, Vogel and Vidrig concentrate in particular, well, all three of them concentrate in particular on the Model Convention, and the Model Convention, as we've seen, excludes the word citizenship and incorporation. So they are commenting on what a criterion of a similar nature might be if the first three criteria you have are residence, domicile, place of management. Just to summarise, Vogel and Vidrig come at this from the point of view of those three criteria have as their connection a sort of substantive, physical, on-the-ground type of link, which they label as territorial. And the conclusion that they both reach is that countries such as the United States that wants to refer to something that is merely formal or legal need to have written into their treaties incorporation and citizenship. Now, pausing there, Vogel and Vidrig might be right, might be wrong about whether or not there's a further split between relevant local connection, on the one hand, any relevant local connection, or this idea of the difference between formal or territorial. this court doesn't need to adjudicate that debate, because here we have the treaty that includes incorporation and citizenship, and our premise is the relevant local criteria has to be either legal or formal, or on the ground physical territorial. Doesn't matter which, but it has to exist. There has to be such a relevant local connecting factor that's over and above mere worldwide taxation. Cousins goes into the analysis in far more detail, but again, ultimately reaches the same conclusion. And there's a long discussion about Crown Forest, and a debate as to, a more detailed debate as to whether or not, in effect, the respondent's approach is right or our approach is right, but in the end, it comes to the same conclusion. So, starting off with Vogel, please. This is PDF page 1329, which is Authorities bundle behind tab 52.
We do have the latest editions here, do we? Because the Vogel 2014 is quite old.
So I sense my learned friend just nodded, but I can double check whether that is right or not. And if there are later editions, then we can put them in the bundle.
Thank you.
I think I'd rather assumed that they were before the first tier, and I have to say personally I haven't checked whether there's a later one since the first tier review.
I would be great for my part.
Yes, we'll definitely check. Yeah.
Yes. There is a later edition, there is a 5th edition, but I think I checked at the time in these particular provisions, there's no change at all in what's said.
Okay, just for the sake of completeness, would it be possible to provide electronic versions of the up-to-date edition?
I'd be most grateful actually, since my learned friends have the hard copy book, if they wouldn't mind sending us a copy as well.
Yeah, it's one of those authorities that's quite difficult to access.
Yes, exactly. Yes, so I would be most grateful if we could please just rely on their hard copy for that exercise. Thank you. So in due course, I'd be grateful if the court could please read the equivalent numbering in the version that we're going to hand up in due course. But essentially, the paragraphs under the subheading in Vogel any other criterion of a similar nature. And just going through this briefly. You'll see that the short debate of 56 to 57, not all connecting factors give rise to full liability to tax are sufficient. Vogel establishes, well, there are two possibilities. One is what he calls functional, i.e. the result is liable to worldwide tax, or territorial, which means what I've just explained. And he says that the better meaning is territorial. There's then a discussion at 58 about the second sentence of Article 4.1 and why it was originally addressed, and that it was originally addressed included to address the issue with diplomats. At 59, so over the page, there's a discussion about seat, and Vogel explains why seat would be a criterion of a similar nature, and that accords with our worldview. There's a relevant local connection. Now, 60 seems to be concerned with a very specific type of deeming provision, which isn't relevant here. But our stance on deeming provisions is essentially you look through them to see what lies beneath, and it's the in real life view of the world that matters. 61 and 62 are then concerned with differentiating between what Vogel refers to as territorial links on the one hand and personal legal links on the other. And Vogel refers to the US Model Convention, which in turn includes citizenship rather than nationality. 63 specifically addresses the question of incorporation. And in Vogel's view, it's that it's necessary for countries such as the US to include that in their treaties. Now, as I've already mentioned, one reason might be that countries such as the US see incorporation as being substantively different to concepts such as residence, domicile, and place of management under their local laws. Vidrig then is behind Authorities tab 50, PDF page 1286. I confess I also don't know if this is the most recent version. I think this is even harder than Vogel to source. But I mean, I suggest that we just check overnight, and if we can find something that's a more recent version, we'll try and get a copy, or at least bring that fact to our attention.
Sorry, what tab are we in now?
So it's Authorities tab 50, please, 50, PDF page 1286. And Vidrig, in essence, ends up in exactly the same place as Vogel, and if I can just point out some of the main passages. So in the introduction, second paragraph, partway through the first sentence, the OECD Model Convention lists a number of connecting criteria that are typically used in the domestic laws for defining residence. So again, focus on the connecting criteria. Over the page 1287, under the heading Defining Residence, second paragraph, generally speaking, residence for the purpose of the OECD Model Convention means a personal attachment to a state which leads to a comprehensive or full tax liability. And we actually saw that notion of a personal attachment in relation to individuals in the OECD commentary itself. Just moving forward, and then by all means, the text in relation to domicile, place of management, and so on, I mean, certainly it elucidates some better understanding as to the different ways that different countries view those concepts. I don't think they're personally necessary for these purposes, but they're there if you wish to consider it. But I'm interested in 8.2.4, so PDF page 1293. Meaning of other criteria of a similar nature. And at the bottom of 1293, partway through the first sentence, all these three connecting criteria have to a certain extent a local connection, meaning that the term other criteria of a similar nature has to have a certain local character. For example... Of a factual nature, yes. Oh, sorry, of a factual nature, yes, those being important words for our case. For example, in case the local domestic law does not use the term domicile for companies, but rather seat as a criterion leading to full tax liability, as is the case with Germany or Switzerland, the term seat qualifies as such other criterion of a similar nature. Over the page, top of 1294, Vidrig, as you'll see, the reference to footnote 30, Vidrig then goes on to say, on the other hand, in effect, if you don't have worldwide taxation as the consequence, you don't satisfy. But that's simply the view that worldwide taxation is necessary. And you'll see that Vidrig has itself in footnote 30, referred to Crown Forest. So the author of this text did not consider anything said in Crown Forest to be contrary to the view that he espouses about the nature of those other criteria. There are then two examples of where factual criteria are included to do with different countries. One thing that I would say, if I can just pause there, the two other examples given here, I'm not going through them just in the interest of time, but they're helpful to us, they support our thesis, so on. The one thing that I would say, though, is at one point in the Upper Tribunal's decision, the Upper Tribunal...
Well, sorry, just to be absolutely clear, you mean the example set out here?
Yes, so Vidrig talks about the country report in France, and then goes on to talk about Italy. And that's the same sort of theory, residence equals local connection. So I'm happy for the court to read those in their own time. They're supportive of our case. What, however, the Upper Tribunal did, without any reference to any authority at all, in its decision, and I'm afraid I don't have the paragraph number immediately to hand, it went on to discuss examples which had just come up via oral submission about, I think it was Italy and Australia, and because we hadn't suggested those examples were factually wrong, somehow that disproved our case. The real problem with looking at other countries' examples is it's all very well to say, oh well, Italy has a deeming provision that's recognised as residence, but I've already explained this morning, well, there are two types of deeming provision. So whether or not Italy has a deeming provision that it and other countries recognise as residence tells you nothing in and of itself. You'd need to know, in order to do that exercise properly, exactly what the national law, just take Italy as an example, exactly what the national law of Italy is, what it understands as a matter of its own domestic law by the concepts residence, domiciled, etc. What then the deeming provision is seeking to do, is it a dark grey equals black, or is it a black is white kind of deeming provision? And then you stand back and you fully understand exactly what impact that example might have in our case. And there is simply not the means to do that exercise at all in relation to any of the examples given in the Upper Tribunal. And I'm not particularly interested in trying to find out what PwC may say about these things overnight in order to work out what these deeming provisions may or may not be. So the Upper Tribunal was simply wrong to indulge in that sort of exercise, and that's not something that we're going to rise to in terms of responding to my learned friend here, because it's simply not an exercise one can sensibly do. So here you have in an academic text a bit of a discussion of these deeming provisions. We're not pointing to them as being gotcha points or otherwise, because they look on their face helpful, but only when you drill down properly can you actually work out to what extent they're helpful or unhelpful, and we don't really have the means to do that here. So bottom of page 1294, please. Discussion of incorporation. Incorporation isn't a sufficient factual link. And then there's reference made there to the US reservation. And over the page, top of 195, the last paragraph, finally, the mere recognition of a company by the international private law of a country or of activity, of the country of activity isn't a criterion of a similar nature either. Then there's a discussion about America and the Model Tax Treaty. There isn't, I don't think, anything in that of particular relevance one way or another. Going down to page 1297, compatibility of domestic deemed residence rules, and over the page to PDF 1298. Again, there's a discussion about deemed rules in relation to companies. And just to summarise what we take from these examples, albeit with the same cautionary note that you don't really know for sure unless you actually...
This may be where the Upper Tribunal got its examples from.
But the point... But equally, we would say you don't have enough here for a court to take a proper conclusive view one way or another. But the point that we get from these cases is that if I was to generalise, anti-abuse rules exist so as to deem a company resident where there is some form of link to the local link to the contracting state, be it activity in the local market, or be it that in fact a company incorporated elsewhere might be managed in Italy. And you've got the examples about Australia and Italy. And so the point that we would say is all that you can take from this summary on any view is that if a contracting state introduces a deemed residence rule, they nonetheless need to be based on some form of connection in order for the contracting state to be required to recognise those companies as treaty resident.
Well, does the commentary suggest otherwise? I mean, I haven't read the examples in the context of the commentary. The commentary as a whole says, broadly, says there needs to be some link
Yes.
in addition to worldwide taxation, as I understand it.
Yes, exactly. But sorry, I'm sorry. Just to be clear, when you say the commentary, you mean the oversee? You mean
no,
this comment? Sorry.
This particular academic
Yes,
commentary,
exactly.
like Whipple,
Yes.
adopts the approach that there does need to be some
Exactly,
link in
exactly.
addition to worldwide taxation.
And that's the way in which it's discussed is the examples. And so if one was to put aside the note of caution I sounded, if you look at the case in Italy, that seems to say that it sets up some sort of irrebuttable presumption. You may be incorporated outside Italy, but if you're being managed in Italy, then there's an irrebuttable presumption that in fact you're deemed Italian resident, unless you can show some evidence that in fact you shouldn't be treated as
Yes,
such.
if you go to the top of 1299,
Exactly.
that first paragraph makes your point.
And so I think all I was trying to do was say that we accept the rough with the smooth. The Upper Tribunal seems to have plucked examples of 3 countries without referring to Vidrig, which it seemed to suggest didn't require any sort of local link, and that supported my learned friend's thesis. It looks like they came from Vidrig, but I don't know how that's possible, given that Vidrig comes to the opposite conclusion.
The Upper Tribunal, in essence, are disagreeing with both Vogel and Vidrig.
Exactly. But I think that the Upper Tribunal seemed to assume necessarily that some sort of purist deeming provision would be sufficient, and we say obviously that's not sufficient. And we would then say, certainly looking at what is said on the face of Vidrig, that very much aligns with our interpretation. I don't know what material the Upper Tribunal based itself on to reach the opposite conclusion, but at that point I would say we just need to be careful looking at these foreign country examples.
There is this, the Upper Tribunal spend quite a lot of time talking about place of incorporation, and they say your case essentially suffers from the difficulty that you end up disagreeing with Vogel and Vidrig on that point. I think there's quite a lot of focus on that. In other words, because, if I may say so, HMRC is taking a rather more nuanced or different approach to what type of connection counts. And you certainly take that approach for the purposes of this treaty. You say you take it for the purposes of other treaties than the OECD, although that's not directly for decision here, as you say.
Exactly. So I think where we get to on Vogel and Vidrig is it may well be the case that in relation to a country such as the US, the words incorporation and citizenship are necessary. It may equally be the case that in relation to the UK, the word incorporation is not necessary. The reason for that is because of how the US and the UK might differently understand the word domicile.
Well, in fact, just to be clear, HMRC's position is it is not necessary for the UK to spell it out, albeit not essential for this case.
Not essential for this case, and in relation to other treaties, exactly. But we HMRC in this case do not need to say with Vogel and Vidrig they're wrong. Our position is in conformity with what they say in circumstances where our treaty includes both incorporation and citizenship. Now Vogel has, and Vogel and Vidrig do not themselves go on to consider what the relevant genus might be in circumstances where you've now got 5. But we say, well, seeing that Vogel and Vidrig have identified incorporation and citizenship as being formal legal criterion, on top of the 3 that they call territorial criterion, we say, well, in circumstances such as this, where you've got a treaty that identifies those 5, we're looking for either a formal legal criterion, such as citizenship or incorporation, bearing in mind what I've already said about incorporation being similar to domicile, or a territorial criterion, so a physical on-the-ground presence, which you certainly understand is meant by residents and place of management. And so either way, our point is, even if you look at formal, legal, territorial, statement isn't any of them, which is my application argument.
Yeah, so going back to the animal kingdom, trout might be included in this case.
Yes, and the only reason for using that example was the Upper Tribunal put so much weight on the words the most similar criterion, or sorry, the most similar in Crown Forest was liability to worldwide tax. And the only reason for the animal kingdom example is to show you that most similar doesn't necessarily mean the only connecting factor, and that's it. And then again, in the conclusion, page 1299, Vidrig again emphasises in the first paragraph under the conclusion that unlimited liability to tax has to be based on sufficient local connection. And then the local connection point is again emphasised in the last paragraph under the conclusion. And if I can go through cousin just very briefly, so that is behind tab 49. And if I could ask you please to turn to page 1121. No, I'm sorry, I've got that wrong. 1211.
Again, can we check how up to date this is, if possible?
Yes.
I can't even see the date on this one, or is it? Oh, 2002, so it's really old.
So I think it suggests that it was printed by IBFD on 17th of August 2016 at the bottom, but again, that's still 8 years old, so we'll just double check that. 1 moment.
Well, last review, top of the page, 1st of September 2002.
Oh, yes, true.
Yeah.
True.
I think there's only ever been one edition.
I'm grateful to my learned friend. He says he thinks there's only been one edition, but we will check all three. So then again, as we'll see from the introduction, PDF page 1211 to 1212. This talks in terms of, over the page, top of 1212, a person is a resident of a contracting state if that person is a resident of that state for the purposes of tax. I've misread my note. That is a formulation that states could have used. That was the Australian-Canada formulation, which
Sorry,
I will
where are you reading from?
So 1212, the top of that page. Part way through, the introduction is talking about the different ways a treaty could be drafted in relation to residents. The example given in that first paragraph is the example of the Australian-Canada Treaty, which I referred to in opening this morning. And there's a further short discussion about that if we go all the way forward to page 1221. Under the heading Some Final Observations, that was the longer passage I took you to. And then page 1222, the subheading you'll see at the bottom, by reason of. And in the first two paragraphs, Cousin again identifies the two separate ways of interpreting that phrase. And you'll essentially see that over the next pages there's a lot of discussion about Crown Forest, 1223 to 1224. At the bottom of 1224, there's then a discussion about domicile, and again, the point is made about that being aligned as a matter of English law with incorporation. Over the page to 1225, the first paragraph under the heading residence talks about what an internationally understood nature of residence would mean. And it refers to that as establishing, and this is in the first paragraph, so about halfway through the first paragraph, a measure of the intensity of physical presence that is compatible with a strong nexus normally associated with residence.
Sorry, I'm losing.
So 1225,
yes,
under the subheading
first
residence, it's about 6 lines down. The
Thank
rule
you.
establishes,
Yeah.
And Cousin observes that different states' rules are not intended to change the general tendency of the word. And then page 1227, there's again quite a lengthy analysis of what any other criterion of similar nature may mean, a discussion, a debate about the 2 potential interpretations, leading to 1231, the conclusion of this particular author. So 1231, first paragraph, about 3 lines up from the end of the first paragraph, Article 4.1 residents are meant to be persons whose liability is premised on a personal or locative attachment.
Rather than the connecting factor.
Oh, sorry, rather than a connecting factor based on the source of income, just to read to the end. So what's being said there is it's the real world personal or locative attachment, and our interpretation of that is rather than the so-called connecting factor of worldwide subject liability to worldwide tax.
Again, I want to say that the accepted but regrettably imprecise term Article 1 meant to refer to those who are subject to residence taxation. Imprecision is replaced by misdirection, where that's replaced by expressions such as full tax liability or comprehensive taxation. No doubt you'd rely upon that.
Yes. But equally, we say in relation to all these academic texts, we're not suggesting, well, it's Vogel and practitioners view Vogel as authoritative, therefore so too should this court. We're simply providing the reasoning. We're relying on the cogency of the reasoning given in all of these academic texts and indeed in the foreign cases I've taken you to. So then the last part of my presentation, if there's nothing else in relation to interpretation that the court would like to ask me about, I was then going to move on briefly to application if we're right. So this is the second part, which is, as your ladyship described it, in effect my learned friend's respondent's note point. So the starting point is we're only worried about this issue if we are taken to be right on interpretation. So liability to worldwide taxation is not the only connecting factor. We necessarily must have one on there needs to be a relevant local connection, because if we haven't one, we've lost already. So that is what it is. So taking it in stages, I've already explained why the US deeming in and of itself can have no effect in helping us answer the application question. So the fact that the US deems GEFI to be a domestic corporation for tax purposes doesn't assist the issue of application, since we are concerned with interpreting and applying the UK meaning of the words domicile, residence, so on and so forth. On any view, given where we are now, since there has been no evidence as to what the US meaning of residence, domicile, etc. means, we're taken for the purposes of this tribunal to assume it's the same as the UK meaning. So the question to ask, we say, is what is the factual arrangement, and is that a similar criterion to domicile, etc., by virtue of a relevant local connection to the US? And we say the answer is no. One, it's clear that GEFI isn't created or organised in the US, so it doesn't have any features akin to domicile or incorporation. Two, its place of management and anything more substantive that might be said to resemble residence in the UK all points to the UK, because there's a UK place of management.
Yes, to the extent it's relevant, which it may not be, there were no specific findings about where this company was managed. I note that there are some board minutes in the bundles that suggest meetings in this jurisdiction. Now, I understand why there weren't any findings, because actually for neither jurisdiction, in this case, is this a relevant point, but I'm just picking up what you just said.
So maybe I can simply put it another way, that there's no evidence that it was ever managed in the US. So there's no evidence to suggest that a place of management is the US.
Well, yes, GEFI certainly didn't put forward evidence to that effect.
And of the evidence that exists, which is the board minutes, they all point to meetings in the UK. So at which point we say, well, you can stop the analysis right there, because you don't have any similar local connection criteria to those 5 things. Now, if we are to examine precisely what stapling is, how do you get to the stapling? Well, that's nothing more than an amendment from GEFI's perspective in GEFI's Articles of Association, and a corresponding amendment in relation to another company's corporate documents. Note that UK shares aren't affected. Now, the weight of UK shares in this case is so small compared to US shares, but in another case, the position may be
You mean the sterling shares?
I mean the sterling shares, sorry, yes. Yes, GB pound shares as opposed to dollar shares. And the only effect from a corporate perspective is that dollar shares of GEFI merely need to be sold altogether along with the shares of GEFI Incorporated. That arrangement in and of itself in no way connects GEFI to the US, apart from tax treatment, but we've already ruled out, if I'm right on the first question, the interpretation question, we've already ruled out tax treatment being the only relevant connecting criteria. So no part of that arrangement connects GEFI to the US. And we say, in effect, the first tier's discussion at 63 to 66 of the first tier's decision is right for the reasons it gave. And if we can look perhaps just to finish off very briefly at first tier, paragraph 64, so that's core bundle, please, tab 12, PDF page 214. Looking then at paragraph 64, my learned friend suggested before the first tier, submitted before the first tier, that in addition to stapling, there was also a connection to the US by GEFI being 100% owned by a US corporation. 2 answers to that. We say GEFI was immediately and directly owned by a UK corporation. It's only the ultimate owner that was US. And the second answer, which is, I think, a point that came up in the discussion this morning, there's no concept of ownership that results in treaty residence. So, sorry, if I can phrase that another way, corporate ownership is not regarded as being a sufficient criterion for treaty residence anywhere. And can I just qualify that? Corporate ownership in and of itself. Corporate ownership combined with other things like management might lead you to a different answer, but their corporate ownership of itself is not anywhere recognised as being sufficient to amount to treaty residence. Why? Because it doesn't have a sufficient locally connecting factor. And Mullennifen may point to the way in which the tax treatment depends on this ultimate corporate ownership in section 269B that we've already looked at. But corporate ownership only bleeds into that, a bit like place of management was one of the factors that was relevant in order to establishing where your effective business was carried on in Crown Forest. At 65, we say the first tier was right to agree with our analysis of connection, albeit the first tier was wrong to suggest that the absence of any evidence somehow counted against us, and I've already explained my reasons why in relation to burden of proof. And that was a matter that we put in our respondent's notice to the Upper Tribunal, so procedurally we've raised the point below and we raise it again here. At first tier 65, the first tier also noted that differences existed from the purpose for US tax purposes. Now there's a debate in the Upper Tribunal's decision as to whether that's right or wrong. The Upper Tribunal decides it's wrong. Short answer is it's actually irrelevant because whether or not similarities exist for US tax purposes doesn't matter, because by the time we get to application, we HMRC have necessarily won on interpretation, so what we're concerned with is non-tax local connections to the US. So I'm not interested whether or not there's a further tax connection.
Yeah, can I just put a marker down in case that we come back to this, of a concern I had when reading this, that the Upper Tribunal at this stage was working out whether there was an error of law, rather than being in the process of remaking the decision, or at least that's arguably the case. And it appears to, when the Upper Tribunal disagrees with the first tier on what the expert evidence means, I pause and think, how is it doing that at that stage? When deciding there's an error of law, given the way the legislation only permits facts to be found if you've set aside a decision.
Yeah.
I appreciate it may not be a big point, but it clearly was relevant to the Upper Tribunal's reasoning, because they make the point and then I think they come back to it in the analysis.
So this is why I think, so I agree. Is the first thing to say. And this is why I think we see this as being two stages. Step one, interpretation. Because if we lose on interpretation, the mere fact without more, that stapling has the effect of subjecting GEFI to US worldwide tax, means we've just lost on application. And so I would agree with your ladyship that whatever the Upper Tribunal was doing here doesn't technically seem to be remaking the decision in circumstances where we've lost already. So maybe it is purporting to find further facts or to disagree with the expert evidence. And I think the reason that I cut to the chase and say, well, actually, it's not legally relevant anyway, it is in effect to avoid any of those types of disputes. So we would say, actually, it's evaluate, and we do say in our skeleton, by the time we get to application, we won in the first tier. That's the end of it. It's not open for GEFI to argue that the first tier got anything materially wrong on application. And I would point to those, and I would say in relation to 65, even if 65 is wrong, getting over for the moment the fact that GEFI will somehow have to overturn finding as a primary fact, even if 65 is wrong, de course it's not materially relevant for the reasons that I've just explained. So pausing there, by the time we get to application, nothing that GEFI has said in writing and nothing that the UT has said are permissible grounds, if we are right on interpretation, to disturb what conclusion the Upper Tribunal, the conclusion the first tier reached on application, which is a matter of fact finding.
Okay, so just to be absolutely clear, your premise in discussing application is that you have won on the interpretation point. We're in the alternative case, if you like, that GEFI are putting forward. And then you say the findings on about US expert evidence are neither here nor there.
Well, yes, our findings of fact, but on any view, are actually at this stage irrelevant, because if we have won on interpretation, we have won because Article 4.1 requires a local relevant connecting factor over and above subjection to worldwide tax.
I think the thing I'm slightly missing there is, could this debate not be relevant to that second question? In other words, is there an additional relevant factor?
Well, as I understand what 65 is concerned with and what the Upper Tribunal were concerned with, it was whether or not there was some difference in tax treatment because of the staple. And the first tier had said, yes, actually, if you look at section 269BE, that's a relevant difference. And Milena Friend's case, as I understand it, and I have to say, I don't particularly understand.
I think we may need to come back to this because I'm not absolutely. I think we should hear from GEFI.
Yes, and I'm happy to deal with it in reply, because on any view we do say it shouldn't be relevant, but if it is, it's not, if I can term it, divorce level material. What's actually material is the absence of a local connection. The fact that Milena Friend may say, oh well, the staple, oh well, ownership, but no treaty, no international norm of resident, or no international understanding of residence.
I'm sure I'm missing the point in this exchange, but is it not a bit simpler? Namely, the question for this court is, did the FTT err in law? And that primarily involves the correct interpretation of Article 4.1.
Yes.
And if you're right on Article 4.1, you say no error of law, end of. Unless
exactly.
the respondent has some other basis for disturbing the FTT's evaluation.
And I'm dealing with this in my opening purely because A, they've mentioned it in the skeleton, and B, my Lady Justice Falk put it to me in some of my questions. Put it to me as a question partway through my opening, whether I was going to deal with it or not. But my Lord, essentially that's it, because anything else about application is fact and we're done. Yeah.
Yes.
That is why my submissions on business are likely to be very short. But so just to conclude, standing back, that's exactly the position. We say the term should be understood to mean any locally related attachment that attracts residence type taxation. It's a two-stage test. All of the weight of authority, etc., supports that. The exercise, therefore, that you have to perform here, which the first tier has already performed, and there's no basis for this court to disturb it, is simply to say, well, does stapling have that local connection? The first tier has found not. We say nothing to disturb that conclusion in facts. So, unless the court has any further questions, those are our submissions on precedents.
Thank you.
Thank you very much.
Mr. Beck.
May it please your lordship, your ladyships. I will, with your permission, I will be presenting the submissions for GEFI on the first issue, that's the residence issue, and Mr. Brinsmate-Stockham will present the submissions on issue 2. Our skeleton on issue 1 is in core bundle at divider 7. I'm not proposing to work through the skeleton. In fact, given the time constraints, quite a lot of the time I will simply be referring you to various material I'd like to ask you to read separately, I'm not going to work through the skeleton. I will refer to parts of it, and if you have any particular questions on it, I'm happy to answer any questions you may have. Just a few quick words about our skeleton. You will have noticed that paragraphs 5 to 42 discuss the Upper Tribunal's decision, you won't be surprised to learn that we maintain that this was a careful, closely reasoned decision, examined the relevant context, other material, and came to the right conclusions. And I have to say, I very much doubt if any arguments I can make now could improve on that judgment. On the other hand, paragraphs 43 to 47 discuss the First Tier Tribunal's rather brief discussion. The discussion on this was at FTT paragraphs 57 to 66. Our submissions are summarised in the skeleton broadly that the FTT made errors with respect to the relevance of the second sentence, and I will have to come back to this question of the second sentence of Article 4.1 because it's a clear error, we say, of the FTT, and I'm not quite certain that my learned friend isn't still following the same argument that is erroneous on the second sentence. The FTT drew incorrect conclusions from the Crown Forest case. It failed to consider the OECD commentary, having cited it. It failed to consider it. It relied wrongly upon the academic texts, and it misconstrued those texts, and it relied, frankly, on a non sequitur in respect to its decision on the second argument, the alternative argument of satisfying the conditions for a connection with the US. Finally, paragraphs 48 to 84 of our skeleton, you will have seen, contain a paragraph by paragraph, and I have to say sometimes sentence by sentence, response to my learned friend's skeleton, as well as the arguments on the expert evidence that are in the permission to appeal. I don't propose to take you through those answers, but if you wish to see our response to any of the points in my learned friend's skeleton, you will see them set out in our skeleton. You will have realised, it's part of the discussion this morning, that there are two alternative arguments. Our primary argument is what my learned friend has called the interpretation argument, the meaning of other criterion of a similar nature. We submit requires only that the relevant law employs a criterion that imposes worldwide or full or residence tax liability. It does not require any additional connection, my learned friends called it the relevant local connection, between the entity and the contracting state. Our alternative argument, if we have lost the interpretation argument and a connection is required, if that connection is a legal or formal connection, then we say that connection is established here because the requirements for section 269B to apply were that it was stapled to a US domestic corporation incorporated in the US. The effect of that was a legal effect that the shares of GEFI could not be transferred unless the stock of GEFI Inc. was transferred at the same time. Secondly, both GEFI and GEFI Inc. were ultimately more than 50% owned by a US domestic corporation. And we shall have to come back to this in light of particularly the recent discussion on the relevance of the evidence of the experts. The evidence of HMRC's expert is that stapling was analogous to incorporation. So that stapling, if there is a requirement that there should be a link, then stapling on the evidence of HMRC's own expert is analogous to incorporation.
Well, can I be clear? My understanding is he was an expert to US tax law.
He was an expert to US tax law, and
so his opinion was it was analogous to incorporation for the purposes of US tax law.
Well, absolutely right. And
I would have been qualified to express an opinion falling outside the realm of US tax law.
Which I think takes us to the point that was discussed this morning. Perhaps I'll address that now, and that is this question of whether one is applying UK tax law or US tax law when one is looking at this point, and I think it's the link with Article 3.2. Article 4.1 has to be applied in respect of each country and the law of each country. Tax treaties, Article 1.1 of the treaty says this convention applies to persons who are residents of one or both contracting states, and it's therefore possible that one can be a resident of both contracting states, so that when Article 4.1 talks about the liable to tax under the law of a contracting state, you have to look at it by reference to each country's law. And so when one is looking at any other criterion of a similar nature, equally, one has to look at each country's law.
You need to make that good by reference to the text of the treaty and the way Article 3.2 is used in Fowler as well.
Okay, well, let's
I don't want to take you out of your course.
I think I'll probably stick to my course and come back to it.
Thank you.
But it's linking Article 4.1 together with Article 3.2, and we say that Fowler and the deeming does not change the way in which one has to apply the treaty.
No, I'm not talking about deeming. I'm just talking about the way Fowler discusses Article 3.2 with Article 4.1.
But then coming back to my course, there is a third possible argument or analysis which was suggested by the Upper Tribunal at paragraphs 147 to 148. And that's where the Upper Tribunal said there is a case for regarding the reference to residence by reason of incorporation as by itself apt to cover a foreign stapled corporation. And the argument there was that the term incorporation in Article 4.1 would cover a foreign stapled corporation, since the US corporation to which it is stapled is incorporated in the US. And as the tribunal suggested, there is therefore a link of incorporation with the US, albeit not GEFI's incorporation, that's certainly correct, but the incorporation of GEFI Inc. We see force in the Upper Tribunal's view on this point, but it's not the way that GEFI has put its case before the FTT or the Upper Tribunal or in correspondence. And so we rely on our primary and alternative arguments.
Right, so you're not...
Not gratefully adopting the approach of the Upper Tribunal there, but it's fair to note.
That's clear, thank you.
Yes. Our submissions then on the primary argument fall into 6 elements, and they essentially follow the same, 7, the same order as my learned friend. And as I go through those, I will respond to some of the points that she made on each of them. Firstly, some brief comments on the approach to the interpretation of double taxation conventions. Secondly, Article 4.1, its ordinary meaning, and the assistance to be obtained from the OECD commentary. Thirdly, and I will deal this as a separate point, the relevance of the second sentence, as I believe that my learned friend's argument still is erroneous on the role of the second sentence, and that is clarified by the commentary and by Crown Forest. Fourth, I'll turn to the international case law. That's the 2 Canadian Supreme Court cases, as well as the Indian and the Portuguese case. I will then say a few words about the expert evidence on US law, and finally I'm going to discuss the academic writings. And then I will turn to our alternative argument that there is a sufficient connection with the US. So taking the first of those, the approach to the interpretation of double taxation conventions, that is dealt with at paragraphs 6 to 9 of our skeleton. It's electronic pages 105 to 106 if you want to note that. There is no significant difference between GEFI and HMRC on the general approach. you've seen reference to the classic statement in the judgment of Mr. Justice Mummery in Commerzbank. And just for a note, that's a bundle A1, divider 21418, electronic pages 430 to 434. That's been endorsed by the Supreme Court in Anson and in Fowler. Additionally, it's been recently endorsed by the Court of Appeal in the Irish Bank case. That's Authorities 2, divider 40, page 835.
I think I ought to add for completeness that it was also picked up in the Royal Bank of Canada
Yes.
case late last year. by
True,
this court.
yes. But if not, I think we don't have that as an authority as well. Yeah. But in the Irish Bank case, it's a paragraphs 15 to 17. There are 4 points I would like to make about the approach to the interpretation. First, the general approach is set out in Article 31.1 of the Vienna Convention. You've seen that. It's a combination of an approach focused on the wording of the Convention and the object and purpose, so that it is relevant when interpreting a convention to have regard specifically to its object and purpose, and that links across to ALTA when I take you to that, because ALTA discusses explicitly the object and purpose of Article 4.1. In respect of Article 31 of the Vienna Convention, context is defined in Article 31.2, but it would be strange not to have regard to the relevant domestic law of the countries concerned, especially when there is an explicit reference to the domestic law, as in Article 4, paragraph 1. And that may again be relevant when one comes to the alternative argument of looking to see what is the connection that is required, and the need to look at, we say, both countries' domestic laws.
I don't quite understand that, because I can understand the proposition that the domestic law of the contracting states is part of the factual background, but when it comes to interpreting the words of the convention, how can they be interpreted in accordance with domestic law? Surely Vienna tells us otherwise.
But there are two ways in connection with tax treaties that this can occur. Firstly, because Article 3.2 makes an explicit reference to the meaning under domestic law, and I'll come back on this point about whether...
Yes, but that's because that's the correct interpretation of the convention applying Vienna.
Yes.
So yes, of course, an international convention in any context, and this is just simply an example of this, may refer you to domestic law, but that's because that's the correct interpretation of the convention.
Yes, I think we're not necessarily saying anything different. Right. Where Article 3.2 says undefined terms should take their meaning under domestic law, the domestic law is brought in.
Exactly so.
That's the point.
Yeah.
The other circumstance where, and perhaps it's a more specific example similar to Article 3.2, and that is where the term of the convention itself makes a reference to domestic law, as does Article 4.1 of the convention, because it specifically says any person who under the laws of that state is liable to tax therein. So it's necessary to look at the laws of the countries to determine who is liable to tax, and that brings you to the meanings under the domestic laws of that state of, if they use them, domicile, residence,
yes,
etc.
all right, but to bring this debate to a focus, the reason why I asked the question is because the words with which we are ultimately concerned are the words any criterion of a similar nature.
Yes.
Now, would you dispute the proposition that those are words in the convention and are to be interpreted exclusively applying the principles laid down in the Vienna Convention, and domestic law is irrelevant?
I think I dispute that, my lord, because any other criteria of a similar nature must take you back to the other criteria that are listed before that, residence, domicile, and those words are to be interpreted in accordance with domestic law. And so any other criterion of a similar nature, the interpretation of those words must draw upon the meaning given to those words in the domestic law, and we say of both countries.
Well, you say that, but you need to come back to the fact that 3.2, which is the route into domestic law, it appears to say something different.
Well, it's a route into domestic law.
So you say another route is in the words of 4.1 itself.
Absolutely, yeah, exactly as I said to Lord Justice Arnold.
Simply because it says under the laws of that state is liable to tax by reason of domicile, etc. Okay, there's an apparent conflict, to put it mildly, between 3.2 and what you say 4.1 does.
Well, may I resolve that? Coming back perhaps to this point there, may I resolve that conflict by noting, I mean, not certain if it was mentioned earlier this morning, Article 3.2 only applies unless the context otherwise indicates. Let me just find it for you. It's Authorities 7 is the provision here, and it's Article page 1, this is Authorities 7, page 115. As regards the application of this convention any time by a contracting state, any term not defined therein shall, unless the context otherwise requires or the competent authorities agree, have the meaning which it has at that time under the law of that state. One always has to approach Article 3.2 by asking the question, does the context otherwise require? I'm sorry, my lord.
It's my fault for trying to ask my question too quickly. I apologise. That begins by talking about the application of the convention. Is it your submission that it extends to the interpretation of the convention on the plane of public international law?
I think it must be yes. The heading of Article 3 is interpretation, rather it's general definitions. And so general definitions are used for the purposes of this convention. This is a general residual interpretative rule. And yes, it must, I think, be at the level of public international law, that the treaty is an instrument in public international law. The Vienna Convention takes the wording of the treaty, Article 31.1, and Article 3.2 is part of the...
This seems to involve the proposition that because the phrase any other criteria of a similar nature is not defined, therefore you look to domestic law to interpret that phrase, which seems a very strange way of interpreting an international treaty.
No, I think it's not that you're looking at domestic law for that. I think it is, as your Lordship said, it's the adjustum generis rule. This is a general category that follows after enumerated criteria. And so one is looking for the common genus, as I think you yourself said this morning, with those earlier terms. And those earlier terms are to be given the meaning in accordance with domestic law. And because you're looking at it from the point of view of both countries, it's potentially the domestic law of each country. I recognise I haven't answered your point, Lady Justice Falk, on Fowler, but just putting together Article 3.
So, I mean, just apply to the facts of this case, you actually say we need to look at US concepts. On the facts of this case. in order to determine whether this entity is resident in the United States?
We do need to look at both UK law and US law.
Why do we need to look at UK law? It's undoubtedly, no one's disputing that this entity is resident in this jurisdiction.
Mm-hmm.
The dispute between the parties is effectively relates to its connection and or status under the law of the United States.
We look at UK law to understand what under the law of the UK those terms mean, and to the extent that we have information on US law, we can look at US law when we look at what those terms mean under US law. And that's where the US evidence to the effect that stapling is equivalent to incorporation is relevant in determining the meaning. That's
right, sorry, just put to one side whether we've got evidence or not.
Yes.
And so putting to one side whether you have to assume that UK law is the same as US law. As a matter of principle, on the facts of this case, are you saying the opposite to what we've heard submitted this morning, which is that you apply UK principles for determining whether this entity has residence, domicile, etc. in the United States?
I am saying that you are not restricted by Article 3.2 to apply only UK principles.
Well, I still don't understand. I mean, I think you must be saying the direct opposite, because you're relying on liable under the laws of that state. You must be relying on in the dispute we've got, on the laws of the United States, because no one's doubting this company's resident in the UK.
I think we're looking for a common meaning to the phrase any other criterion of a similar nature.
No, we're not dealing with that, because I think you've agreed with my lord that has a treaty meaning. What we're talking about is effectively what it relates to, the list of identified items.
And those items, we are not restricted by Article 3.2 to look only at the law of the United Kingdom in terms of those items. We may also look at the law of the US. We may also be guided by the commentary to the OECD model and what it says as to the meaning of those terms. Those terms, what I'm saying is that those terms are not limited by Article 3.2 only to the law of the UK. So I disagree with my learned friend. My learned friend gets there by saying that Article 3.2 takes you to the UK meaning. I'm saying
you are partly applying Article, despite your, unless the context otherwise requires, you are effectively in part applying Article 3.2, because you're saying look at both at the UK and the US.
I'm saying that you don't need Article 3.2 at all. The discussion this morning about Article 3.2, I think, did not assist, because there is an explicit reference to under the laws of that state and a dual resident entity, you're looking at the laws of both states, but also this is a treaty based upon a model, and we've seen that the wording, subject to the addition of incorporation and citizenship, follows the model, and therefore we are entitled to have regard to the OECD commentary in looking at the meaning of that wording. And that's, if you look only at the UK meaning, why would you look at the commentary? The commentary is guidance to the interpretation of the model, and this treaty is based upon the model. I was commenting on Article 31 of the Vienna Convention. Just to note, I spoke about the context in terms of the object and purpose. The object and purpose of a double taxation convention as a whole is to avoid double taxation. the specific object of Article 4.1 is to define which persons are regarded as residents of a contracting state. To treat a stapled entity fully taxable on a worldwide basis in the US, but not include it as a resident of a contracting state is a surprising result, which leaves effectively a lacuna. It creates, as the Upper Tribunal indicated, a form of second-class resident, an entity that is resident in the US as a domestic, treated as a domestic corporation, liable on its worldwide income, but not entitled to be treated as a resident of the US by the UK for treaty purposes, which is the result of Miller and Friends submissions. My second comment on interpretation is it's now well accepted that interpreting double taxation conventions based upon wording contained in the OECD model, it's appropriate to have regard to the commentary to the relevant articles, and that's confirmed by Fowler, internal paragraph 8, it's authority 41 at paragraph 18, and perhaps if I may, I will take you to that, just to make good that role of the commentary. This is at electronic page 8. Um, 870. The OECD commentaries are updated from time to time so that they may, and do in the present case, post-date a particular double taxation treaty. Nonetheless, they are given such persuasive force as aids to interpretation as the cogency of their reasoning deserves. And if I might just ask you for yourselves to read the remainder of that to the bottom of H on page 871, and also may I also just note paragraph 30, 31 and 32 on the fiction point, and I'll come back to the issue of treating a fiction in connection with tax treaties. Lord Justice Arnold, you asked earlier today the basis in the Vienna Convention for references to the model and to the commentary. I think possibly there might have been some confusion there between references to the model itself and to the commentary.
Well, stage one, I would have thought, is the model, because if you can't refer to the model, I don't understand how you can refer to the commentaries on the model. So stage one is why you're entitled to look at the model.
So far as looking at the model is concerned, I agree with the conclusion of my learned friend this morning that the HMRC confirmed that it can come under Article 32 because it is. So far as the commentary is concerned, there are various arguments as to how you bring it under Article 31 or 32. There is lengthy academic discussion on the point, and there are views expressed that take virtually every part of Article 31 and 32 as a basis. But one particularly cogent argument, it starts at the beginning of Article 31, which says the treaty shall be interpreted in good faith in accordance with its wording. A good faith obligation. The United Kingdom and the United States are both parties to the OECD. They both participate in the preparation of the OECD model. They enter into a treaty with knowledge of that commentary at the time that the treaty is concluded. And it is a matter of good faith that one would expect both countries to have regard to the commentary when they are interpreting the treaty.
You distinguish between commentaries that pre-exist the treaty at hand. If they pre-exist the treaty at hand, it's a preparatory work and there's no difficulty. If they're post-date, there's two ways of looking at it. One is the way that's adopted in Fowler, which is essentially to treat it as an academic commentary worthy of respect to the extent that it's cogent, in which case it has no different status to any other academic commentary. The other way of looking at it is that this is subsequent practice of interpretation, and so you bring it in under that head of
There's certainly academic writing that supports those views there, but there is also, as I say, a cogent argument that there is a good faith element in having regard to the treaty. I don't need to push that because your lordship is clearly aware that there are the bases for having regard to the commentary. My third point on treaty interpretation, reference was made to the Irish bank case. That's bundle A2, divider 40. The Court of Appeal declined to follow 3 decisions of foreign courts, but the general approach to foreign case law is still that set out in Commerzbank, and just for your note, it's at internal page 298, bundle A1, divider 21, page 431, which says decisions of foreign courts on the interpretation of a convention or treaty text depend for their authority on the reputation and status of the court in question. And I'll come back to that when we look at the foreign authorities, but I note that the Crown Forest and Ulster cases are decisions of the Canadian Supreme Court, a court of very significant authority and reputation, and particularly with regard to the Indian Income Tax Appellate Tribunal that my learned friend relies upon. That is a first instance court in India, subject to 2 levels of appeal. Finally, Commerzbank notes, I've given you the reference to the Commerzbank.
The reference you said, I think I've got the wrong page number for Commerzbank. What's your talk about reputation and status?
I have bundle A, authority A1, page divider 21, page 431.
Thank you.
And it refers to the writings of jurists to be used as an aid to interpretation. Their use is discretionary and not mandatory, depending on the relative weight to be attached to them. May I turn then to the second element of our submissions, and that is on the ordinary meaning of Article 4.1 and on to the OECD commentary. You've seen Article 4.1 several times. We say that the phrase is used to identify as residents of a contracting state those persons who are subject to worldwide or full taxation, that's sometimes referred to as residence taxation, in one or both of the states under the domestic law of that state. And the treaty contemplates potential dual residence, hence the need for the tiebreaker provisions. That's consistent with the object and purpose of the Convention, which is to relieve double taxation. Persons who are liable to worldwide taxation are potentially exposed to double taxation if they receive income which is taxed in the country of source, or if they're regarded as a resident of both contracting states. And Article 4.1 identifies such persons as residents of a contracting state. And I've already referred to Article 1 of the Convention, which says it applies to persons who are residents of one or both of the contracting states. So to benefit from the treaty, you have to be a person and a resident. Therefore, you must come within the personal scope of the Convention. So when the commentary refers to personal, it is adjectively basis of the word person. It is a connection of the person. Person is defined in Article 3, and it is one of the requirements to come within the scope of a treaty that you are a person and a resident. The ordinary meaning on its face of Article 4.1 requires nothing other than liability under the domestic law of a contracting state by reason of the taxpayer fulfilling one of the connecting factors that give rise to taxation on a worldwide or full basis. Those are the specifically enumerated criteria: residence, domicile, or by fulfilling a criterion of a similar nature. On the face of Article 4.1, there is no additional connection with a contracting state other than worldwide liability to tax. There is no requirement of any additional connection in the wording of Article 4.1. It's just as Falk looks puzzled, but the wording simply requires liability on the basis of one of the connecting factors or any other criterion of a similar nature.
Well, that's the point, isn't it?
Exactly, but the point I'm making is that there's nothing is said about any further connection other than fulfilling one of those criteria.
Right, so that gives rise to two questions, and the questions are related, so I'll ask them both at the same time. You use the expression connecting factors, which I can well understand and seems to me to be highly appropriate, or a criterion of another similar nature. So that suggests that you're submitting that the phrase "or criterion of another of a similar nature" is not a connecting factor. So that's question one. Is that what you're saying? It's not a connecting factor. Secondly, you accepted earlier that it was an eus generis provision. That being so, what's the genus?
It is a reference to a connecting factor used in the domestic law of either of the states. So if a state has a connecting factor that is not one of those enumerated, and we say stapling to a US corporation is such a connecting factor, then it is that criterion is a connecting factor. Then you have to ask, does it fulfill the genus? And the genus is imposing liability on a worldwide or full or residence basis. That is the genus. Melanie Frank's example earlier of elephant and so on and trout doesn't really help you very much, because you in that scenario, you don't have a guiding principle as to what you are looking for. Whereas here you are looking for connecting factors that impose liability in a country. And so you are looking for connecting factors not specifically enumerated, but which have the same generic quality, the same genus, as the ones that are identified. And you look, sorry to repeat myself, under the laws of the different countries, and you also look for guidance from the commentary on the meaning of those terms. Focusing then on any other criterion of a similar nature, that is a sweep-up category, if you like, following the specifically enumerated criteria. It derives from the OECD model. It reflects the fact that not all states apply only the enumerated criteria, if you like, the enumerated connecting factors, and that there may be connecting factors that states employ to impose full or worldwide taxation that are not in the enumerated list. And stapling in the United States is an example of this. To be a similar criterion, it must reflect the same common feature. And we say that the common feature is that they are all, the enumerated categories, used by states to impose worldwide or full taxation. That is the genus, if one's applying the adjustment generis rule.
So it's inherent in that submission that you say that the common feature is not geography. Can you explain why not?
Firstly, because there is no explicit reference to any geographical feature in Article 4.1, so on the ordinary meaning of the words. Secondly, because when one looks at the commentary, and in a moment I'll make the point that this is consistent with general principles, a treaty does not dictate to countries how they should exercise their taxing rights, and therefore does not dictate any local or geographic requirement. And that's consistent with what is said in particular in paragraph 4 of the commentary to Article 4, and I'll take you to that because my lady friend, I think, rather rushed over some of the provisions of paragraph 4. And we say that that is that the Canadian authorities in particular indicate that there is nothing that one can draw from Article 4.1 other than the requirement of liability on a worldwide basis, and rejects, specifically ALTA, rejects any additional criteria, including a localized or geographical criteria. The Maloney-Fred relies really for that on Vogel, but properly understood, Vogel in a treaty like the UK-US treaty would have to accept that there is not a territorial or geographic requirement because of the reference to incorporation or citizenship. Perhaps if I illustrate that, you may be a citizen of a country if you are born to parents from that country outside and never have any geographical link with that country. Your link is purely a legal one through acquisition of citizenship.
Can I ask a slightly different question, prompted by what you said towards the beginning of that submission? Would you accept that a key part of the purpose of Article 4.1 is to place a limit upon the ability of contracting states to impose worldwide taxation?
No, we do not accept that.
I thought that was what you were going to say.
Yeah.
And I'm just intrigued as to what the rationale for that would be, because if you're not going to limit the ability of states to impose worldwide taxation, what's the point of it?
The treaty is there to relieve double taxation, taking as it's given the taxation laws of the countries concerned. Countries determine for themselves the scope of their taxing jurisdiction, and that may extend to taxation of profits, for example, of subsidiaries outside the country. Controlled foreign corporation legislation taxes profits made outside the country by a subsidiary. It's for a country to determine its own scope of taxing jurisdiction, and the OECD is quite explicit in the commentary that it does not lay down standards. It's not the role of a double taxation convention to dictate to member states how they should exercise their taxing jurisdiction. Given their taxing jurisdiction, the role of the treaty is to eliminate double taxation by limiting the tax on income having its source in the country, or by providing, for example, for relief by credit or exemption. The only extent to which one could say that a treaty limits jurisdiction is perhaps the non-discrimination article, which does prevent countries from operating broadly in a discriminatory fashion. But otherwise, tax treaties take the country's tax law as it stands.
Well, that's not entirely true, is it? So, for example, just to take an example, Article 11 switches off source country taxation that would normally arise. I mean, that's a rather generalisation, if I may say.
Forgive me, then I have to explain that there. It doesn't stop a country imposing source taxation or determining what income have its source. But given that it has jurisdiction, the state then agrees to relieve double taxation by...
Article 11.1 switches off source country taxation where it applies. It doesn't just give a credit.
But
if you had UK source income paid to a US person and Article 11.1 applied, then, assuming you've gone through the right process, withholding tax, the normal tax that applies on UK source income, could not be charged. So I think you're making too general a point, if I may.
I think we're talking at cross purposes there, my lady. The tax treaty does not dictate to a country whether or not it taxes interest, what under its domestic law it defines as interest, or what withholding tax it imposes on that interest, or what source it defines, how it defines the source of interest. It does, though, seek to relieve double taxation in several ways, and one of the ways is by reducing the normal tax either to a lower level or possibly to zero. But that's not dictating to the country how that country it drafts its own domestic law on that, and that's my point.
I agree with that. Maybe now's the appropriate time to raise this point or question. If HMRC were to succeed in this appeal, that, I'm leaving to one side issue 2 for the moment, the net effect would be that for treaty purposes, this entity is just solely resident in the UK.
Yes.
That would appear to mean, I know what Section 269B says, would appear to mean that for treaty purposes, the US should not be taxing this income under the terms of the treaty.
Yes.
It still asserts that under domestic law, but under the terms of the treaty, it is not entitled to tax this income.
That's not quite correct.
Right.
Because of the treaty's savings clause.
I know, but that, if you look at it, well, maybe we need to look at it,
Yes, we can.
talks about an entity that is resident for treaty purposes in the US. And if HMRC has succeeded in this appeal, it's not obvious to me that that provision applies.
But from the US point of view, the US would still regard the GEFI as a resident of the US for treaty purposes. This decision, your decision...
Well, no, I understand that, and maybe that's the point, and that's what I wanted to pull out. Were the US to, which I'm sure they won't, to agree that a decision in the UK that the treaty, that this entity is not US resident for the purposes of the treaty, were they to follow that, they should not be taxing this income under the terms of the treaty and ignoring 269B.
Yes, but they won't. That's the answer.
That's the point I wanted to get.
Your decision does not bind the US.
Of course not.
There have been 2 rounds of MAP proceedings.
No, the reason I wanted to bring it out is because it seems to be, it might be relevant to a debate about, oh, this leaves this company doubly taxed, that sort of point. some points are being made about, oh, it's a second-class citizen, it can't obtain the benefit of the treaty. Well, if HMRC is right, it's a UK entity that can fall within the treaty.
And that would require the UK to grant credit if there were any US tax, which they would say there should not be any US tax.
Yeah.
But the US, initially it was thought in this case that the US would not grant credit because they would not recognise the decisions of the UK. It has now, after some discussion, become the case that the US is understood that it will, or there has not been a definitive answer.
No, I know what you said in the skeleton on that. I know it's not definitive, but yes. The short point is that, as I understand it, the US's position, and I think this is clear from the paperwork, is that this entity is US resident, both under 269B and under the treaty.
Yes. That is the US position, you're quite right, and it is clear from the paperwork there's that. And I should point out that that would have been also the US's position at the time when the treaty was negotiated. I will mention briefly the Memorandum of Understanding in the US-Netherlands Treaty that the HMRC's own expert confirms and referred to the Memorandum of Understanding and took from that the US would regard this, regard GEFI as a resident of the US for treaty purposes, and that has always been the case. The legislation in question, 269B, was not. It has not been introduced after the treaty was concluded.
No, I know that. I'm trying to understand. This is not because this point is directly relevant to determine this case. It's more a contextual point to understand the implications of a decision either way.
Taking it away from the specific circumstances of this case, it must follow that if there are entities that are regarded as subject to worldwide taxation under the law of a country, and yet the view is taken that there are some overriding principles derived, we don't know from where, that limit the jurisdiction of a state, that you have effectively two classes of taxpayers, those who are subject to worldwide taxation, have treaty access, and those who have subject to worldwide taxation, but who are regarded as not having treaty access because they do not satisfy this, whether they're geographic or legal or factual connections. And as is recorded, no examples have been brought forward of a situation where that arises. HMRC's criticism of our view on the ordinary meaning of the word of Article 4.1 is that our approach deprives the words by reason of any meaning, but the words by reason of any meaning. That, with respect, is not correct. A taxpayer may be liable to tax in a state on a residence basis or a source-only basis. If Article 4.1 only said that a resident must be liable to tax, that would include persons liable on a source-only basis. Article 4.1 instead says liable to tax by reason of residence, domicile, etc. The reason for the liability, the causal connection, has to be a criterion that imposes worldwide or full taxation and not merely source-only liability. And in saying that the enumerated criteria and the residual category all have the common feature that they are basis for imposing worldwide taxation, the words by reason of are actually essential in the text of the treaty to describe the cause of the liability to tax. The cause has to be the fulfillment of a criterion that gives rise to worldwide or full liability. HMRC also say in their skeleton that Article 4.1 could simply read, a resident is liable to worldwide taxation. But of course the wording here derives from a model to be used by many different countries. And the approach that has been taken has been to identify criteria that are commonly accepted as imposing full or worldwide tax liability, and adding the sweep up to cover further criteria that are less commonly used but are used by specific countries also to impose worldwide tax liability. Our approach preserves the formulation based upon the OECD model, and it ensures that the treaty applies to persons who are taxed on the enumerated criteria, as well as persons taxed on a less common criterion connecting factor, but also on a residence basis. My learned friend made the comment briefly this morning, the submission briefly this morning, and it's in her submission, that our approach suggests that the terms of the same effect really mean of the same nature, and that the use of the terms of, sorry? I think
you mean the other way around. Similar nature, meaning of the same effect.
I'm sorry, the same effect, yes, that's right. Yes. The Upper Tribunal discussed that argument and rejected it. The approach that we take is entirely consistent with the words chosen. Similar leaves flexibility, and it would not exclude an additional criterion if it were not exactly in the same terms as one of the enumerated criteria. The criteria are all of the nature of connecting factors that may be used to impose worldwide full or residence-based taxation. That is the nature of the criteria. Fulfilling one of the criteria has the effect that the taxpayer is liable to taxation, but the criteria themselves have a nature. Only by fulfilling one of them do you have that effect. Now, if I may, I'd now like to turn to the OECD commentary and show how that is supportive of our case on the ordinary wording of the Convention. The commentary you've been looking at is the 2001 version, which is at divider. Sorry, I've been looking at the 2017, but I'll turn to the same one.
Divider 6.
Divider 6. You've been taken to some elements of the commentary, but if I may, I'm going to take you to certain points that have not been referred to. Firstly, very briefly, you were shown paragraph 1. This is page 100 electronically. The concept of a resident of the contracted state has various functions and is important in 3 cases. First, in determining a convention's personal scope of application. And I note there the use of the word person. That links back, as I've mentioned earlier, to Article 1.1. A treaty applies to persons. And so this, the function there is to determine how the treaty applies to those who are persons, falling within the definition of persons in Article 3. And where the commentary refers to personal attachment or personal scope, it is in that context of those who are persons as defined for the purpose of the treaty. It also solves cases where double taxation arises, and double taxation arises in the context of the state of residence and in the state of source or situs. Paragraph 2 has been read to you. You will see that the article also resolves questions of double taxation and refers to the two typical cases of conflict. Paragraph 3 was only partly read to you, and if I may, I'm going to take you through the whole of paragraph 3 and paragraph 4. Generally, the domestic law of the various states imposes a comprehensive liability to tax, referred to as full tax liability, based on the taxpayer's personal attachment to the state concerned. Millennium Friend places a great deal of emphasis on the use of the word personal attachment, but as I've indicated, personal links in with the definition of those who are persons for access to the treaty, who come within Article 1. This liability tax is not imposed only on persons who are domiciled in a state, in the sense in which domicile is usually taken in the legislation, private law. The case of full liability tax are extended to comprise also, for instance, persons who stay continually or maybe only for a certain period in the territory of the state. Some legislations impose full liability tax on individuals who perform services on board ships who have their home harbour in the state. Perhaps that is an example of not a direct geographical link at all. It's a link with a ship that just happens to have its own harbour in the state. Conventions for the avoidance of double taxation do not normally concern themselves with the domestic laws of the contracting states, laying down the conditions under which a person is to be treated fiscally as resident and consequently is fully liable to tax in that state. They do not lay down standards which the provisions of the domestic law on residents have to fulfill in order that claims for full tax liability can be accepted between the contracting states. In this respect, the states take their stand entirely on the domestic laws. That, Lord Justice Arnold, is, I think, the answer to your question. Does the tax treaty impose limits on the jurisdiction, on the choice of the jurisdiction of the states? It is very clear. It says they do not lay down standards which the provisions of the domestic law have to fulfill in order that claims for full tax liability can be accepted between the contracting states. They stand entirely on the domestic laws. It's purely a matter of domestic law of the states concerned, how each state determines its own tax liability. Right at the very beginning of this morning, there was some discussion about the possibility of a country changing its tax law to include income arising outside that jurisdiction. There may be a difference between a change after a treaty has been concluded and a country adopting a broad definition of jurisdiction beforehand. But if a state has a broad claim to tax jurisdiction, the other contracting party takes it as it is. By entering into a treaty, it accepts that the country has that jurisdiction. So it may be different if a country subsequently changes. And we'll see that in ALTA, there is some discussion about subsequent changes. But otherwise, a tax treaty does not impose limits on the choice that states make. There are then paragraphs that were mentioned briefly on paragraphs 5 to 7 on an example of conflict existing between two residents. This manifests itself quite clearly in the cases where there is no conflict at all, but where the conflict exists only between residents and source. The same view applies in conflicts between two residences. The special point in these cases is only that no solution of the conflict can be arrived at by reference to the concept of residence adopted in the domestic laws of the states concerned. In these cases, some special provision must be given to determine which of the two concepts of residence is to be given preference. There is no priority given in the treaty itself to claims of jurisdiction. The treaty does not recognize one claim as being preferential to another. Rather, the treaty contains tiebreaker rules that determine those situations where there is a claim of taxation in both countries. I'm sorry, Roger.
But isn't the example that they go on to give demonstrate what they mean by that, which is that, of course, both states are free under their domestic laws to say that Mr. A is subject to full taxation, but that inevitably gives rise to a double tax conflict, which has to be resolved by the convention. And the resolution is that state A gets preference, and to that extent, state B does not get preference.
Absolutely right, and that is determined.
And therefore, state B is limited in its power to tax that individual to this extent.
To that extent, but it does not contain a preference rule between the approach taken by one country or another. Instead, there are separate tiebreaker tests which then determine between those countries which country, in a sense, wins. And it's not a case of giving preference to one country's connecting factors over another, but rather determining that by external factors which look at factual issues. In the case of individuals, those are permanent home, centre of vital interests, habitual residence. In the case of companies, that used to be the test of place of effective management. It's now left to the contracting states to determine the dual residence. And that's the explanation of 5 to 7, the paragraphs 5 to 7. Those paragraphs indicate that a rule has to come from the treaty. There is no priority given between one country's connecting factors and another. That's consistent with paragraph 4. The reason that these follow up to paragraph 4 is paragraph 4 is saying we rely upon each country's own choices, and then the tiebreaker will resolve any conflicts between those choices. Paragraph 8, I think you've only shown part of those paragraphs, if I may. Time-wise,
we're running out of time, so maybe you could wrap up quickly on this point.
I had thought we were going to 4:30.
No, we need to rise a little bit before that.
Okay. Well, then let me just very briefly take you to paragraph 8, and I'll pick that up from the morning. Paragraph 8 says, paragraph 1 provides a definition of the expression resident of a contracting state for the purpose of the convention. The definition refers to the concept of residence adopted in the domestic laws. As criteria for the taxation of the resident, the definitions mention domicile, residence, place of management, and other criteria of a similar nature. As far as individuals are concerned, the definition aims at covering the various forms of personal attachment, which in the domestic law form the basis of comprehensive taxation. It also covers cases where a person is deemed, according to the taxation law of the state, to be a resident of that state, and on account thereof is fully liable to tax therein, e.g. diplomats or other persons in domestic government service. You were shown that, but I don't think that you were